Good afternoon, everybody. Thank you for joining us for the 11th webinar in Conn Maciel Carey's 2016 OSHA webinar series. Today we're going to be talking about OSHA issues that arise during and after acquisitions and divestitures. I'm joined today, this is Eric Conn, the faceless voice that you're hearing over the webinar channels. I'm joined today by my associate, Lindsay DeSalvo. You may remember her as Lindsay Smith. Recently married and changed her name, so don't be confused. Let me do a little bit more of an introduction about ourselves, and then we'll jump right into today's topic. I am one of the founding partners of Conn Maciel Carey and chair of the firm's OSHA Workplace Safety Practice Group. My practice focuses exclusively and has for the last 16 years on all aspects of occupational safety and health law. I practiced for more than a decade alongside the first general counsel of the OSH Review Commission and have since, during that time and since, represented employers in inspections, investigations, and enforcement actions, primarily involving OSHA and the state OSH plans, but also involving the Chemical Safety Board, MSHA, and the Environmental Protection Agency, generally where there is overlap with worker safety issues. I handle all aspects of OSHA litigation, from appeals of citations to criminal investigations and prosecutions, and I write and speak regularly on OSHA law topics. I know many of you have heard me speak regularly on OSHA law topics here on the OSHA webinar series and elsewhere, and I'm delighted that you all could join us today. I'll have Lindsay introduce herself, and then we'll cover our topic.
Good afternoon, everyone. I'm Lindsay DeSalvo, and I'm an associate here at Conn Maciel Carey in both the OSHA and the labor and employment practices. So in that position, I represent and advise employers on all aspects of the employer and employee relationship, and this can also include reviewing handbooks and workplace policies and procedures, providing guidance on any changes in employment and labor law. And then on the OSHA side, I also help and support in inspections and investigations, work on defenses for enforcement actions and advise employers on those defenses, and also help develop audit safety and health programs.
All right, so today we're talking about acquisitions and divestitures from the OSHA workplace safety and health perspective. So there's a handful of topics that I thought made sense to cover under that umbrella, starting and most importantly focused on successorship issues under the OSH Act. And really, what are the circumstances that a acquiring entity is going to be held responsible for either past violations, past liabilities related to OSHA and worker safety issues, and how might they be held accountable in the future for new punitive elements based on the past conduct or past conditions that were observed at a location or involving an asset that they have acquired from a predecessor company. And there are some unique aspects of successorship that apply in the OSH and OSHRIC context that do not apply in other areas of the law. So there are a lot of myths that are held about continuing liabilities and extending liabilities and assuming liabilities that are not as many employers would expect in the context of worker safety. And under that specific umbrella, we'll be talking about exposure to repeat violations based on prior employers' violations. We'll be talking about punitive elements like how the severe violator enforcement program handles past violations of a predecessor, and how you may actually even buy into the SVEP program by acquiring a qualified SVEP employer. We'll talk about who is responsible, predecessor or successor, for past civil penalties and abatement requirements that were accrued under the prior owner's operation of a facility or an asset. We'll talk about specific requirements outlined in the OSHA regulations about the transfer or maintenance of records that relate to the operation of a business, relate to an operation of a facility or an asset under the predecessor's control. Which of those records need to go from the predecessor to the successor, and what duties does the successor have to maintain those records, and the predecessor to maintain records even after a transfer of ownership. And then finally, we'll talk about some due diligence strategies around safety and health issues, which tie all of this together. Where there is potential exposure, what should you be asking for? What types of analyses should you be doing early in a transaction process so that you're best prepared to eliminate some of these potential carryover liabilities, or best prepared to manage them in the event the transaction goes through and you do assume some of these responsibilities. So let's dig right into successorship under the Occupational Safety and Health Act. There is an old myth, and myth may not be the best word, but let's start from that perspective. That there is an old myth that that a buyer avoids employment law liability of the prior owner if the acquisition is by asset purchase, or the transaction agreement includes a broad disclaimer of continuing liability or successor liability. And the reason why there is that old myth, there's good reason for it, is that is the general rule as it relates to most liabilities. But the purchaser of another company's assets does not, as a general rule, assume the seller's liabilities. However, one of the major exceptions to that general rule is employment law, labor law liabilities. And there are, a host of federal court decisions over history that reinforce this exception. And here's one that really summarizes it well from a federal district court in New York. It says, Congress did not intend for the federal courts to impose successor liability, where, as here, the violator sold the entire operation to another entity which, in essence, merely continues the business using the same premises, same machinery, same employees, and same supervisors. Congress did intend, pretty important distinction there. Congress did intend the federal courts to impose successor liability as it relates to labor law obligations when there is a substantial continuity of the prior business operation. So if you're buying an asset and then continuing to run it in essentially the same way, with the same people, with the same equipment, with the same goal, producing the same product, so to speak, generally for the same types of customers, that there is such continuity of business operations that you will be considered de facto a successor employer, regardless of what your transaction agreement says, and regardless of whether the prior predecessor employer continues to operate as a viable entity and operate other businesses, and even to operate as a competitor of yours in other markets. If you acquire an asset, a plant, contracts, what have you, and you operate in substantial continuity, federal law intends for labor law liabilities to run from the predecessor to the successor. Now, how does that apply in the specific context of OSHA, one type of labor law? Well, we'll talk a little bit about the history here, because we moved 20 years ago in 1998. OSHA put out an interpretation letter that seems to contradict what the federal courts were saying, and definitely contradicts the current position that OSHA and the OSH Review Commission take. But let's talk about that evolution. Starting back in 1998, OSHA responded to an interpretation letter request from Tetra Tech. And in this context, Brown & Root discontinued its business in environmental services and agreed to sell all of its related assets to this environmental service business to Tetra Tech. And primarily those assets were existing contracts to provide environmental services to various customers. So it was an asset transaction. In the execution of the agreement, there was also an agreement that Brown & Root would, say at 2 p.m. on the day of execution of the agreement, terminate all of the Brown & Root employees who were providing these environmental services, and at 2:01 p.m. on that same day, Tetra Tech would rehire all of those same employees, and Tetra Tech would carry on the operation of those assets. They would service those contracts with the same employees out of the same workspace, providing essentially the same service to the same customers. But in this circumstance, Brown & Root continued as a very much a viable entity, providing business services in other areas other than environmental service. And in that context, OSHA responded in this interpretation letter that because the predecessor entity was continuing as a viable business, just not in that space, that Tetra Tech was not to be considered the successor employer. And OSHA pointed to, in support of this conclusion, old Supreme Court decisions from the 1960s and 1970s, which generally focused on successor liability, not really in the labor law context, but just generally. And an important factor in evaluating successor liability was the availability of the predecessor entity to provide requested relief. So if it's, abatement of violations, payment of penalties, accomplishing recommendations from, loss control surveys, things like that, if that entity still existed and was available to provide relief, then there's not a successorship issue there. Now that test, we provide that as an example to show that OSHA has moved, and to some extent the courts have moved, but certainly the OSH Review Commission that hears appeals of OSHA, contested OSHA citations, has moved over the last 20 years, and there is a different test out there now, and that is the substantial continuity test that we talked about. So the focus is no longer on whether the predecessor still exists and is in a position to provide relief, but instead is about substantial continuity of operations. So about 20 years later, there was a new interpretation letter issued by OSHA that was grounded in more recent Supreme Court case law talking about successor liability in the context of labor law. And here, OSHA pointed to, in the 2008 letter, Supreme Court decisions that talked about when an employer purchases a plant and in that context hires the predecessor's employees, that employer has a duty to bargain with the union that was in place and established and had a collective bargaining agreement with the predecessor employer when there is substantial continuity with the predecessor's operations. And the Supreme Court took the position that, hey, this is fair to hold the new employer accountable for the labor law obligations of the predecessor because the new employer is benefiting from an established workforce, an established trained workforce, and benefiting from the sort of the infrastructure of the prior employer. Same location, same equipment, same employees already trained to perform the job that you're asking them to do, to service customers that are by and large the same with the same product. In those circumstances, it is fair to hold the new employer accountable to the labor law obligations because they're benefiting from all of the historical labor relations at that workplace. And OSHA, declared that, hey, that's pretty consistent with the purposes of the OSH Act as well. The Supreme Court's view of, requiring you to bargain with the old union, that makes sense in the OSH Act context as well, because we're all about ensuring safety and health, and you are benefiting from existing safeguards, existing safety programs, existing safety training that's been provided to all these same employees. So it is fair then to impose on you all of the obligations under the OSH Act that would have run to the predecessor employer as well. So the Supreme Court and OSHA, in the context of this interpretation letter, sort of developed and said, hey, this substantial continuity test is what is important to us in determining successor liability of safety and health related obligations, safety and health related liabilities. And this test is a totality of the circumstances test. There is not one single factor that determines whether you will be found to be a successor. It is on balance, on a totality of factors that we'll review together in a moment. But the focus of the analysis is whether the new company has acquired substantial assets of the predecessor and continued without interruption or without substantial change the predecessor's business operations. And in this 2008 interpretation letter, OSHA provided some examples of what they meant by continuing operation without interruption or without change, being making the same products, using the same processes, employing the same workers, using the same tools. Those are the sort of things that will go into this totality of the circumstances test to evaluate successor liability. And one important point that OSHA made in this letter is that to the extent that the asset purchase agreement, that the written agreement between the acquirer and the seller provides differently and provides that there shall be no successorship liability following from this agreement, that agreement is not binding on OSHA. Now, that agreement is relevant. It is an important factor that will be considered, but it is not binding. So you can write as forcefully as you want in your asset purchase agreement that all labor law related liabilities remain with the predecessor. If OSHA does this analysis of substantial continuity and finds that the totality of circumstances dictate a conclusion that you are a successor, it will not matter how forceful your language in your agreement says to the contrary. So that was OSHA, the agency itself, speaking about their view of successor liability. Now let's talk about the OSH Review Commission. What is the independent body of judges? What do they think about successor liability under the OSH Act? And they've spoken to this issue very directly in the seminal case of Sharon and Walter. And the Sharon and Walter case was a construction case where I believe you had a bunch of fall protection violations by Sharon and Walter 1, the employer. And here are the facts of that case, that the employer, ABC Inc., I think it was Sharon and Walter 1, received a bunch of violations from OSHA, either contested or accepted those violations. Those violations ultimately became a final order of the OSH Review Commission, either confirmed through a hearing or confirmed by a settlement or confirmed just by a lack of contest of the citations. So Sharon and Walter 1 goes out of business and resurfaces a month later as Sharon and Walter 2. And it is essentially the exact same employer, the alter ego of Sharon and Walter 1. It is the same owner, and it is a small, closely held company with essentially one controlling person performing the same work, roofing work, construction work, whatever it was, for generally the same types of customers, and in some instances, the exact same customers, using the same employees, the same tools, the same everything. So it is, the fact pattern in that case was alter ego. And it would have been a perfect opportunity for the Review Commission to just say an alter ego is a legal successor for OSH Act obligations and for accountability of prior violations of the alter ego predecessor, alter ego. It was the classic alter ego fact pattern. What the Review Commission did, however, was go a lot further than they needed to go to find successorship here. They could have just said, hey, Sharon and Walter 2 is the same company, but for this minor name change, and so we're not fooled by this, this switcheroo, we're going to hold you accountable. Instead of doing that, they wrote the decision to really memorialize this substantial continuity test that OSHA had been promoting. And the Review Commission in the Sharon and Walter decision basically said that an employer is going to be responsible for the predecessor's violations if the successor operates with substantial continuity. And by substantial continuity, we, the Review Commission, are talking about three different buckets. And again, it's a totality of the circumstances analysis of the continuity in these three buckets. And the three buckets were nature of the business, jobs and working conditions, and relevant decision makers. And so here is a breakdown of what the Review Commission is talking about. Under nature of the business, the elements of that bucket that the Review Commission looks to are the type of business. Are you a construction company just like the predecessor? A roofing company specifically like the predecessor? Are you in the business of refining petroleum like the predecessor? So type of business, and we've seen cases where that is evaluated at a very high level or at a very micro level. So we've seen cases where the Review Commission has said, or at least where OSHA has done the analysis and said, the old entity was a petroleum refinery, you are a petroleum refinery, there is substantial continuity. Other cases, the analysis gets a little bit more detailed where you say, we're producing different types of refined products with different blends, different throughput, different customers, things like that would be relevant in the analysis. But from my perspective, anecdotally, OSHA, when making an evaluation about successorship, this is the enforcement agency making the assessment, is going to do a very superficial analysis. I mean, even to the point of saying, this old factory was a manufacturing location, and today it is still a manufacturing location, so that's continuity of the nature of business. Even if the old employer manufactured car parts and the new manufacturer manufactures modular homes, they are only similar in the sense that they both are manufacturers, but that is, from my anecdotal experience, enough for OSHA to try to hold the new employer accountable for past violations of the old employer. The Review Commission would hopefully do a more meaningful analysis, but if you're trying to figure out what's OSHA likely to think, they're going to do a superficial analysis and try to find successor obligations everywhere they can. The nature of the business test also accounts for the facility operation, the location itself. Is it the same building, the same general layout, configuration, and tools, and the production process? Are you following the same operating procedures or same general mechanism of producing the product or delivering the service that the predecessor offered? Are the products and services offered substantially similar? Are the customers served substantially similar? And that's the same types of customers or the same specific customers. And then the second bucket that the Review Commission considers in the totality of circumstances looking for substantial continuity is jobs and working conditions. The types and number of jobs and positions. Is it generally the same number of employees, the same specific employees, the same types of jobs, a maintenance person, a manufacturer, a forklift operator? If it's generally the same types of positions, that would be a factor demonstrating continuity. Continuity of operational employees, continuity of programs, procedures, and policies. So, for example, if you actually adopt the old safety manual, if you adopt the old operating procedures of the predecessor, that's going to be an important factor in the analysis of substantial continuity. And then conditions of the work, conditions of the workplace. And here, again, we're talking about the context of safety and health. So, my view would be, and the way I would try to prove a lack of continuity before the Review Commission would be focused on conditions related to safety and health. So to the extent that we added additional, fire suppression equipment and introduced new personal protective equipment and introduced new engineering controls to address, the potential for exposure to chemicals, in all of those ways, I would point to the way that the conditions related to safety and health are different. I would also go outside the context of safety and health if there were other important distinguishing elements, but remember that the focus here is about safety and health continuity. So in all of these categories, the first place to begin is safety and health issues like, the number of employees involved in safety and health, the types of procedures and policies related to safety and health, the conditions related to safety and health, and then go beyond that, but that should be the starting point. And then the last bucket, which is very much safety and health focused, is the continuity of the management personnel who control safety and health related decisions. So to the extent that the safety director under the predecessor company remains in place as the safety director at the new acquiring entity, that's going to be a very important factor to OSHA and to the Review Commission in evaluating whether there is substantial continuity. And the Review Commission in the Sharon and Walter case carved out this piece specifically to say this factor weighed heavily in our determination of substantial continuity. And remember the facts in Sharon and Walter that there was the owner of the company, who is a small, closely held company, where a person controlled more or less all of the management decisions of the company. It was the same person. So that's a very clear picture of substantial continuity in those circumstances. In many of these acquisition situations that you may be dealing with, there's going to be new management personnel in place. And to the extent that you put in more new management personnel in the safety and health roles, the better off you are in sort of cutting that line of continuity. The Review Commission also indicated that they would look to sort of all levels of safety personnel, so it's not just management level, but they would also look to, your safety committee, for example, and if you have, representatives on the safety committee who are not necessarily management, but who have, significant influence over your safety and health program, your safety and health culture, and those people continue from the predecessor, or if they are new and different from the predecessor, that will be a factor in this determination. So by and large, this slide right here is the big test from a safety and health standpoint for figuring out who is going to be considered a legal successor for OSH Act purposes and who is not. And then, we looked at the Sharon and Walter case where they found substantial continuity. Now let's look at another more recent case that was just decided by an administrative law judge, the Wynnewood case, Wynnewood refining case. It has not been decided by the Review Commission. It's on appeal to the Review Commission. So we're all anxiously awaiting to see what the Review Commission does in these circumstances. But here, an employer who had recently purchased a petroleum refinery from a predecessor operator of that refinery received a handful of repeat process safety management violations, and the acquiring entity had no prior similar violations on their record. But the predecessor, the former operator of the refinery, did, and those old violations of the predecessor operator were used as the basis for repeat violations during a new inspection of the new acquiring employer. The administrative law judge, doing an analysis of doing the substantial continuity analysis to determine whether the repeat characterization was proper in the case, basically looked at the first two buckets, the nature of the business and the jobs and working conditions, and said there's no real dispute as to the substantial continuity of the nature of the business and the jobs and conditions. However, there is significant change in the third bucket, in the managers who control safety-related decisions. And as a result just of the substantial change in management over safety and health, the ALJ, the administrative law judge in this case, determined that Wynnewood was not a successor for OSH Act purposes, and therefore repeat violations were not appropriate in the case because there was substantial new management responsible for operations and safety. Corporate management was actively involved in daily operations, and they were all different than the predecessor, and that the new acquiring entity doubled the safety personnel at the refinery. And so as a result of all of that and major improvements of the safety policies and procedures and culture, that last bucket carried the day for this administrative law judge to say that these are not, should not be appropriately characterized as repeat violations. That case is on appeal to the Review Commission. It will be interesting to see what the Review Commission does with that analysis. But you can see now that there are these sort of, two different paths that the OSH Review Commission may take. And it looks like there is truly a very important factor is management determination. And Sharon and Walter, the same owner, same decision maker, that's a successor. In Wynnewood, different management, different decision makers on safety and health issues, not a successor. So there's a pretty small pool of cases in this issue, so it's hard to really hang your hat on either one of these, and especially with the Wynnewood case just being an ALJ decision at this point. But that is right now what we've seen out of the Review Commission, that management control is an important factor. So I'm going to turn it over to Lindsay here to talk about repeat violations, severe violator, and some other important issues, and I'll be back later.
All right. So good afternoon again. We're now going to spend some time talking about one significant implication of successor liability, which is this concept of potential repeat exposure. So Eric just touched on this a little bit in that prior slide in regards to the Wynnewood case. But under the substantial continuity test, there is repeat exposure for things that an employer has never been specifically cited for in the past. In other words, an employer can acquire repeat exposure by acquiring another asset or entity. And as you can see on this slide, there are three major elements that OSHA needs to establish to classify a citation item as repeat. One of those elements is that the condition or hazard for which the employer is cited is substantially similar to a condition or hazard for which it has been cited in the past. So this is going to kind of come down to whatever the hazardous condition was that was the basis for the citation. Is that similar? Is the hazard that was created by that condition similar to something that was already cited in the past? Another element is that there must be a final order of the review commission that includes the relevant prior citation. OSHA policy states that it will look back 5 years in a citation history to determine if there's a basis for a repeat citation. But OSHA is not bound to this time frame and has actually in the Wynnewood case, went beyond that 5-year citation history. And then finally, and most relevant to our current discussion, the current employer and the predecessor employer that received the prior citation and that would serve as the basis for the repeat must be considered the same employer. And this is where the substantial continuity test comes in. Because if there is substantial continuity between the current employer and the predecessor employer, they will then be considered the same employer for purposes of issuing this repeat violation. OSHA issues a repeat violation, and an employer would still have the opportunity to prove, using those elements that Eric just went over, that they're not actually a successor and there's not substantial continuity there to establish a basis for repeat violation. But OSHA could assert that it exists and cite the employer for a repeat violation. Based on the recent increase in penalties, a repeat classification could mean a substantially higher penalty. Now employers face up to almost $125,000 penalty for each repeat or willful violation, which is obviously significant. Sorry about that. And then another significant outcome of this is that it could be the basis for the employer potentially qualifying for the severe violator enforcement program. So this is another basis upon which an entity can receive a repeat citation if there is substantial continuity with the predecessor. And it's important because there are already, as you can see, several avenues that you can get into the Severe Violator Enforcement Program, or SVEP, and repeat citations are significant in this analysis. As many of you may know already, an employer is entered into SVEP based on the citations that's issued to it after an OSHA inspection, and before the employer has even had an opportunity to contest the citations or the validity of the citations. And the program has a number of significant implications for employers, including but not limited to nationwide inspections of related work sites, enhanced follow-up inspections, potentially enhanced settlement provisions, as well as just the publication of the employer's name on a log that's available to the public through OSHA's website, associating the employer as being a severe violator. So this slide displays all the ways in which an employer may become eligible for SVEP, and the three most pertinent to this discussion are the last columns that you see in this chart. Obviously, looking at that last column there, an employer that acquires a company that has already qualified for SVEP will have to deal with the consequences of being in the program.
I would just make the point that if you look at OSHA's SVEP log on their website, the SVEP designation essentially runs with a location as opposed to an entity. So you'll see that the same entity may be on the log 3 or 4 times at different establishments, at different locations. So it is, and we have seen employers or entities that have acquired a grain elevator, for example, from a location that had qualified into SVEP, and that new acquirer, their name just got slapped up on the SVEP log when the location changed names. So they basically bought themselves an SVEP qualification. So it does run kind of location by location, and you can very much buy your way into this program, which seems like a real treat for a new owner.
Right, and then columns 3 and 4 also show how an employer can qualify for SBEP based on just the number of willful, repeat, or failure to abate citation items related to a high emphasis hazard or the PSM standard. And particularly significant is column 3 as the basis for entry into the severe violator enforcement program, because this is the route through which most employers actually qualify for the program and are entered into the program. Indeed, 68% of SBEP qualifying cases are based on receiving 2 or more willful or repeat or failure to abate citations related to a high emphasis hazard. And even more relevant in this context is the fact that of those SBEP cases, 75% are based on repeat violations. So the fact that a successor employer can be exposed, to another basis for receiving repeat citations where it did not even actually commit the prior violation used to support that repeat classification is really significant. This is part of the reason that due diligence prior to acquisition, which Eric is going to touch on a little later in this presentation, is so important. An employer really should be aware of the predecessor citation history for a number of reasons, one of which should be to try to limit the potential exposure for repeat violations. So being aware of what the predecessor may be cited for in the past, really making significant efforts to ensure that that couldn't be used as a basis for repeat violation going forward once an acquisition takes place. And then separate from the repeat classification potential, there are other ways the acquisition issue could come up for a successor employer. Specifically, from a penalty standpoint, there may be circumstances where you, as the successor employer, could be obligated to pay the penalty associated with citations that were actually received by the predecessor. We see this most often where the predecessor goes out of business completely, just completely ceases to be an entity engaging in any sort of business activity, and is no longer available to provide the relief that OSHA might be seeking. This makes the language of the acquisition agreement really important. Eric touched on this a little bit before, that these agreements, although not necessarily determinative of anything, are definitely useful. In this case, you can use the acquisition agreement to specify who has a legal obligation to pay the OSHA penalty amount. And in particular, as if you were going to be the successor in this case, specifying that the penalty will be the obligation of the predecessor. And again, although this language is important, the agreement is important, it may not be determinative, as OSHA could still attempt to pursue penalty recovery from the successor employer. But, definitely something that would be used to support any, argument that the successor should not be held liable. OSHA would also likely hold the employer liable for abatement actions. Where a hazard still exists, the employer would have to abate it anyway. The new employer, the successor, would have to abate it anyway to avoid, continued exposure to a potential violation. However, if, the case is settled in a settlement agreement and a specific type of abatement has been agreed to in the settlement agreement with OSHA, OSHA likely would expect a successor to fulfill the obligations as set forth in the agreement, and may try to enforce the agreement against the new employer in that case. So once an acquisition has been set up, it's important for both the successor as well as the predecessor to understand what records have to be either transferred if you're the predecessor, or in the case of a successor, which records need to be maintained by the new employer. In that regard, we often receive questions from our clients as to what types of records must be transferred and retained. And OSHA guidance explains that records required to be preserved by OSHA regulations must be transferred to the successor employer in most circumstances. The successor employer will then have the obligation to retain the records for the regulatorily required period, based on the specific regulation at issue. So we'll spend some time now just kind of going through the different types of records that would have to be both transferred by the predecessor and maintained by the new employer or the successor. So this slide just kind of gives you a brief rundown of the types of records that OSHA regulations require to be preserved. These records are required to be preserved for a specified period of time based on the regulation, and we're going to go through each of them in turn to discuss, specifically what the retention period is, as well as what obligations actually attach to both the predecessor and the successor employer. So the first one here are the OSHA injury and illness records. So injury and illness records must be retained for 5 years, but they are unique in the sense that they also have to be updated throughout that 5-year period. Specifically, the OSHA 300 logs must be updated with new information throughout that full 5-year retention period. And how this works is that when the employer receives new information about a prior recorded injury or illness that would materially alter the record, as well as the understandability of the nature of the hazard or injury or illness that's recorded, the employer would be expected to revise the prior entry on the OSHA 300 log to reflect that information. For example, if a knee injury originally only required medical treatment, but 3 months later, 3 months after the point that it would have had to be recorded, it requires days away from work to recover from a surgery. The entry for that particular injury would have to be updated to reflect not only the fact that this has now become an incident that required days away, but as well as to reflect the number of days that the employee actually had to be out, after the surgery took place. It's important to note that the regulation does not require that 300A forms or 301 incident reports be updated during the 5-year period. It's just the 300 log that is required to be updated during the 5-year period. It's within the employer's discretion, to make other changes if it gains new information, but the standard requires that 300 logs only be updated during the 5-year retention period. Finally, you see on the slide that we've noted that an employer is not currently required to submit these records to OSHA unless requested by OSHA or BLS. But as many of you probably know, although this is the current standard, that is set to change in July 2017 when certain employers will have to start submitting their injury and illness data pursuant to OSHA's new electronic record-keeping rule.
Yeah, I was going to ask a question about that. Do you see any interaction between this historical obligation to transfer or to assume the 300 logs from a predecessor and the new electronic record-keeping rule? Will there be any interface between those two? Is a successor going to be impacted by this requirement under the new electronic record-keeping rule? Right? I assume the answer is, if you're required to assume those records in the year that you make the acquisition, starting the spring of the next year, you're going to be reporting data from your predecessor, but it's going to be it's your data at this point. Is that how you think this will play out?
That would be my understanding. I mean, when you're passing this data along, the expectation is that it will be retained in the same manner that the regulation requires. So if the regulations are now going to require that it also be reported to OSHA electronically, then I think that obligation would likely follow as well. So as I stated prior, injury and illness records, specifically the OSHA 300 logs, 300A forms, and 301 incident reports, must be retained for 5 years. Therefore, that responsibility transfers to the successor employer. As to new injuries and illnesses that occur, after this transfer happens, the new employer will only be responsible for recording and reporting incidents for that period of the year for which the employer owns the establishment. And although the obligation to retain the injury and illness records transfers to the successor, the new owner or employer does not have to update or correct injury and illness records under 1904.34 of the record-keeping regulation. So although they have to fulfill the obligation to retain the record for 5 years, they do not have to fulfill the obligation of updating and correcting prior recorded injury and illnesses that occurred before they actually, took over ownership and became the new employer. Now, we do see that this could create some tension with OSHA's proposed rule to extend the statute of limitations period for record-keeping violations. OSHA has proposed a rule that would extend that statute of limitations period from 6 months, as was established in the Volk's decision, to 5 years, pursuant to this 5-year retention period. The expectation that would set is that entries should be updated and changed throughout that 5-year period. But they do have this regulation that specifically states that the employer does not have any sort of obligation, or the new employer, the successor employer, does not have any sort of obligation to, update those prior recorded injuries and illnesses for the 5-year retention period. So it'll be interesting to see, if OSHA has any guidance on that particular element if this proposed rule does go forward and is issued by the agency. So another set of records that are applicable to this discussion are employee medical and exposure records. They're required to be maintained for a specified period under 1910.1020 based on whether they would be considered an exposure record or a medical record. Specifically, exposure records generally must be maintained for 30 years, and medical records must generally be maintained for the duration of employment plus 30 years. Employee medical and exposure record standards specifically requires that a predecessor employer provide all exposure medical records to the successor employer once they cease to do business. And then the successor employer is required to retain those records for the duration of the regulatorily mandated period that I just reviewed. However, there is OSHA guidance out there explaining that the obligation is different if a predecessor employer remains a viable functioning entity. And this is actually the interpretation letter that Eric was discussing earlier, that 1998 interpretation letter. And in that letter, OSHA explained that it retains the responsibility, that the predecessor retains the responsibility to comply with the requirements of 29 CFR 1910.1020 regarding retaining medical records specifically. That's what the letter actually dealt with, for employees working in the predecessor's business prior to the effective date of the transaction. So again, this letter specifically speaks to medical records, but there's no reason to believe that OSHA would take a different position, in regards to exposure records, as both types of records are covered under the same standard. And then finally, if there is no successor employer to which the predecessor can transfer its records, the predecessor must notify its employees that they have a right to access the records, and they must do so at least 3 months prior to the business actually, ceasing operation. So employee exposure records can include a lot of different types of documentation that would be required to be maintained pursuant to the broad definition of an exposure record that's specified in the regulation. The standard specifically lays out those documents that are shown on this slide, that first section up there, in its definition of employee exposure record. So you see there, you're required to maintain environmental monitoring, biological monitoring, SDSs, or chemical inventories. And so although, they specify these different types, there's a lot of different documentation that can fall within each type that would need to be maintained. The standard and OSHA's guidance also makes exceptions to those things that have to be maintained for the full 30-year period. And you'll see a couple of examples up here. OSHA has specified in its regulation that background data to environmental monitoring may not have to be maintained for the 30-year period. Specifically, it may only have to be maintained for the 1-year period if it meets certain requirements as far as having the necessary information still available to give context to a particular exposure. And then also you can see there's a certain exception for maintaining SDSs. There are also specific standards that set out a certain retention period for particular types of data and documents. And in that case, those retention periods may preempt the retention period provided in 1910-1020. And one example of that we'll discuss briefly today is documentation related to the hearing conservation program. There's a specific time period provided in the noise exposure standard that only requires retention for that specified period of time. And then this slide just demonstrates sort of the analysis that an employer would have to go through in determining what sort of records would have to be maintained as exposure records. This analysis would have to be conducted probably by both the predecessor and the successor, so that the predecessor knows what documents it has to transfer, and the successor understands what records it would be expected to maintain for the required retention period. As you can see by just taking a look at this slide, the analysis can be quite complicated for certain records, and the types of records that OSHA would expect the predecessor to transfer to the successor employer can be quite voluminous. This tool is actually available through our blog, the OSHA Defense Report, if you want to check it out in more detail. And then finally, in regard to 1910-1020, medical records must also be maintained, employee medical records, and they must be maintained for the duration of employment plus 30 years. The documentation associated with this requirement is also extensive, and you can kind of see what it would require here. Descriptions of medical treatment, medical opinions and diagnoses. So it would be records evidencing these types of information that would be expected to be maintained as employee medical records beyond, I think, what may be seen as more obviously to be a medical record. And then there's also some exceptions that don't need to be maintained as an employee medical record, and that also don't need to be transferred by the predecessor employer as a medical record. Health insurance claim records, first aid records for one-time treatment by a non-physician, and then records of employees who worked for less than 1 year. Third, successor employers have a certain set of obligations related to work environments that require hearing conservation programs. So in acquiring a work site, OSHA guidance now requires that the successor employer rely on the baseline audiograms that would have been taken by the predecessor employer for employees within the hearing conservation program to use in comparing the results of future audiograms that are required by this particular standard. The baseline audiogram is used to determine whether an employee experiences a standard threshold shift in his or her hearing, and if that occurs, the employer might have or would have additional obligations under the standard to prevent any sort of negative further impact on the employee's hearing. So it's important that the original baseline audiogram be used for this purpose. The successor employer must also continue the schedule of audiograms, which for employees that qualify for the hearing conservation program are done annually, as well as any required noise monitoring, if noise monitoring is triggered by exposure to a designated level of noise within the workplace or the work environment, depending on the type of job the employee performs. As I said before, this particular standard provides a different retention period than the retention period established in 1910-1020. So noise exposure measurement records required by this standard must only be retained for 2 years. And OSHA guidance has explicitly stated that this 2-year retention period is the one that should be applicable here. So with that, I will now turn it over to Eric to discuss the requirements related to the PSM standard.
All right, thanks, Lindsay. So we're talking about the specific context here where there's likely to be duties that run from successor to predecessor, or where there might be exposure to repeat violations based on the conduct of others, or where there's some duty to maintain records. And in process safety management, risk management program issues under the environmental side, PSM issues on the OSHA side, there are a handful of items that do run from the successor from the predecessor to the successor, but really the analysis that we've seen from the Review Commission and from OSHA is that it's not even really a successorship issue. It's that PSM and RMP, as sister regulations, focus on the process. So it's not about running from one employer to the next. It's about these obligations remaining with the process, regardless of who owns or controls the process. So you've got here, the RMP submission itself, the document that you have to submit to EPA and is publicly available about your RMP program. There are likely going to be activities, I think there's certainly going to be activities that will be required to a new employer. If you still have an RMP covered process, you will need to update your RMP submission to correct, at the very least, ownership information and perhaps other information about individuals who have important roles with the RMP program. Then you talk about process hazard analyses and compliance audits, these two sort of core elements of PSM, where on a periodic basis, PHAs every 5 years, PSM compliance audits every 3 years, that the recommendations and the PHAs themselves, the PHA documentation, need to be preserved for the life of the process. You need to keep the PHA, the revalidations, and documentation of the resolution of recommendations for the life of the process. So that's a document that if you're the acquirer of an asset or a business that has a PSM covered process, that you need to make sure you're obtaining these records as part of the transaction and make sure that you're maintaining them going forward. There is not a requirement to conduct a new initial PHA, because you can rely on the predecessor's PHA, because the idea is that it's the process that is the focus of the standard and not the employer. For compliance audits, you're required to maintain at least the last 2 audit reports with documented resolutions and recommendations from the audit. So that's something as a predecessor you need to make sure that during an acquisition, during a transaction, you are getting access to, and that you know how to access them if you're requested copies of them by the agency during an inspection. Or, more important than just being requested copies, making sure that the recommendations have all been addressed. And that's a big issue that we'll talk about before we get into due diligence, is how these duties like timely addressing recommendations from PHAs and from compliance audits run with the process. So if you are acquiring an asset that has a PSM covered process, you've got a duty, the Review Commission has said in some cases, to go back and look at the old recommendations and make sure that they are all addressed. And if they are not addressed, you have a duty to address them. And if you don't, you will be exposed to, not only, this context of repeat violations we've talked about, just an initial violation of your own for not addressing a recommendation that was made by a different entity. So it is important that you get access to all of these PSM required documents in a transaction so that you can determine whether there are pending obligations that have not been met yet that you will be held accountable for because you are the new owner of this process. So PSM incident investigations is another document you're required to keep under the PSM standard for 5 years. Make sure you're getting those in the transaction. I would actually say, when we talk about due diligence, make sure you're getting these before the transaction so you know what potential liabilities are out there, you know what potential duties are out there and have yet to be met, and you know what potential past violations are out there that you are now buying into as part of your record that could serve as a repeat violation. So as we talk about these records and the things that Lindsay was talking about, records that you're required to keep as the new successor employer of that, of that business, that those are also documents to, put into your due diligence list to think about things to access when you're still evaluating the transaction and evaluating what new liabilities and obligations you may be acquiring, unknowingly acquiring in the deal. The process safety information file is something you're required to maintain for the life of the operation, and so that is important to transfer from predecessor to successor, and it's important for successor to evaluate to see if it is complete. This is probably the most frequently cited standard is either PSI or mechanical integrity issues, and so you're relying on someone else's work in compiling this process safety information file. A good idea to get a hold of this before a transaction and evaluate, is it a complete file? Is this something that OSHA would consider to be compliant with the PSM standard? And if not, you need to prepare to enhance that file when you take ownership, or put some responsibility on the seller, the predecessor, to more fully develop the PSI file before the transaction closes. Management of change, pre-startup safety reviews. One thing that you should consider doing in the early stages of taking over an asset that includes a PSM covered process would be to do a management of change for what the change in ownership, what potential hazards may be introduced because of a change in ownership. OSHA has, at various different stages, indicated that MOCs are required for administrative changes, not just physical engineering changes. It's not clear how the Review Commission or the circuit courts may come out on that, but it can't hurt to do the MOC because we think that OSHA may consider it to be required. You keep your MOCs and PSSRs until the next PHA. So make sure in an acquisition you're getting access to those records, or that you're acquiring them during a due diligence process. Operating procedures, they're required to be certified annually that they're current and accurate. So you need to acquire the predecessor's operating procedures or immediately implement your own, but ensure that you have a recently certified SOP from the predecessor. Make sure that it is current and accurate. Another good exercise to undertake or to try to undertake during due diligence. Emergency action plans. There's probably going to be changes that will be required in an emergency action plan that is required under the PSM standard. So when you become a new owner of a prior PSM covered process, make sure that you're promptly evaluating the emergency action plan to look for any updates that are necessary as you take ownership. For example, identifying people who are key contacts in the event of an emergency. I have seen citations issued where an emergency action plan says the first person to call for this type of incident is the shift supervisor, when the shift supervisor title no longer exists under a new management structure. The employer was cited for not updating the emergency action plan with the new titles or the new people or the new phone numbers that need to be utilized in an emergency. So make sure you're evaluating that in a transaction. And then your mechanical integrity records, you're required to document inspections and tests and maintain them for the life of the process. You've got to make sure that you're getting those records in a transaction. Similarly with training records that are required to be done at periodic intervals. You can rely on the predecessor's training, but I would definitely encourage you to get hold of those training records to be able to validate to OSHA and to yourself that training was done at the intervals that were required. We talked a little bit about the Wynnewood case, but the Wynnewood case, as much as that was a PSM case, was really just an analysis for our purposes today of the substantial continuity test. The Delic case, which is on appeal from the Review Commission, really is a good analysis of your continuing obligations, specifically under the Process Safety Management Standard in an acquisition setting. In this context, Delic purchased a refinery from a predecessor operator back in 2005, and the end result of that acquisition was that Delic inherited, according to the ALJ and the OSH Review Commission, that Delic inherited the recommendations from the prior owners, PHAs, and compliance audits. And Delic was subsequently cited. This was not about whether, Delic is held to a repeat violation based on a prior violation of the predecessor. This is about whether Delic should be cited in its first instance because it did not follow through on recommendations that were made by the predecessor during PHAs and compliance audits that were done by the predecessor before Delic owned the refinery. And Delic asserted that it did address those recommendations, or that those recommendations all had been addressed, just not documented. But the Review Commission, whether it agreed with that or not, essentially they said they did not agree that had been done, and they did find that Delic had that responsibility to do that because these recommendations don't run to an employer, they run with the process. So these things were inherited by Delic. They did have an obligation to conduct these activities, and these activities were continuing violations, and so they lived beyond the 6-month statute of limitations from when the recommendations were made by this predecessor employer. The Review Commission confirmed the citations, holding that the schedule set by the PSM standard for auditing and abating hazards is not reset by the sale of a facility. So you don't get a new clock, and you don't get to sort of wipe them off the books. That they exist, they run with the process, and the timing to address them promptly continues from the time of the recommendation, not your transaction. The Review Commission found evidence in the language of the PSM standard that showed that the PSM standard focused on the process, not the employer, and so that these obligations continue after transfer of ownership. And so that's, application of this continuing duty in the PSM context. So let's talk real quick about due diligence, and then we'll wrap up the webinar today with some questions. So things that I think are important for employers to ask for, acquirers to ask for in due diligence would be the selling entity's history of OSHA citations at that location, or if you're buying the business, all of the entities' past OSHA violations at any of their facilities around the country. And the reason being, as we discussed, if you are determined to be a successor for purposes of OSHA Act obligations and liabilities, that those citations become part of your record and can serve as the basis for a repeat violation. And if they serve as the basis for a repeat violation, they could well be the reason that you qualify into the dreaded severe violator enforcement program. And now that we've seen penalties jump for repeat violations up to about $125,000 per violation, and the severe consequences of the severe violator enforcement program, you want to make sure you understand what you're buying. What is my record going to look like after I buy this? And then look at this 5-year period. I'd say look back 6 years at least, because OSHA is not technically bound by their 5-year look-back period, to see how has my past OSHA record changed because I've acquired this asset or acquired this business. Make sure you evaluate within any past enforcement actions or any past settlement agreements or any past orders of the Review Commission any abatement commitments that were made by the predecessor, to make sure, A, that they've been completed, and B, to make sure you don't slip back out of compliance with something that has been abated by the predecessor. So if commitments were made, or even enhanced compliance or enhanced abatement commitments were made, that are not technically required by the law, but they are now technically required at that location because they were committed to by the predecessor in an old settlement agreement, you need to understand those obligations because you could be found to be in a failure to abate situation, which has daily penalties if you are not meeting the obligations that were set by a predecessor if you are found to be a successor. You want to look back at your predecessor's audit recommendations. And we talked about PHAs in the context of process safety management, compliance audits in the context of process safety management, but even outside that context, if you have periodic audits that have been done either by the insurance company, loss control surveys, internal safety audits, third-party safety audits, audits that were done by the safety committee at the location, those findings are sitting out there, and they will be held to be significant evidence by OSHA to serve as the basis for potentially willful violations, to demonstrate employer knowledge, even if they are not regulatorily required items. So for PHAs and compliance audits, OSHA is going to come in and say, you didn't address these, that's a violation of the PSM standard. If it's a loss control survey from your insurer that says, you've got a combustible dust problem, we recommend increasing your housekeeping, and OSHA comes in a year after an acquisition and sees that you've got a combustible dust issue or accumulations of dust in a part of your plant and finds this old audit, and they ask for audit reports all the time, even though that audit was done under your predecessor's period of control of the plant, they're going to say, look, you acquire this knowledge, you acquire these responsibilities as a successor, and there is essentially a general duty responsibility that this entity developed when you got this audit recommendation, and you've got to see it through. And if you didn't see it through, we're going to hold you accountable as the successor, and that might mean evidence of knowledge to support a violation or even evidence of willfulness for not addressing the findings. So make sure in due diligence that you are accessing any type of prior survey, audit, inspection, investigation that has been done by the predecessor or on behalf of the predecessor by a third party at their direction. And evaluate the open recommendations or whether they're open or not, understand what sort of obligations the old predecessor employer has assumed because of those recommendations, and make sure that they're either continuing or that they're addressed in some other manner. Employee complaints. You want to find out if there's been prior employee complaints internally or certainly any knowledge of an employee complaint that was made to OSHA and get access to those and make sure that the conditions that were raised in those complaints have been addressed or that you address them promptly when you take control, because those are the sort of things that OSHA will find and use as the basis for knowledge of a violation or willfulness, and you are assuming all of that knowledge when you are considered to be a successor employer. So those are the types of records, and then very specifically, each of the categories that Lindsay and I talked about. Make sure you're getting the injury and illness record-keeping records you're required to maintain, the hearing conservation records, medical and exposure records, the PSM and RMP-related records. That should be part of due diligence so you know whether you're walking into a compliant program or one that needs help, or just know that you are meeting your obligations to take those records and preserve those records. And thinking about almost all of those categories that Lindsay talked about, those standards have some requirement that they be readily accessible to the employee or readily accessible to the government if they ask for it in an inspection. So, it would not be okay to say, oh, okay, employee is looking for a copy of all of his exposure records. Give me a couple of weeks to go back to the predecessor, ask for those documents, get them, and share them with you. That's a violation right there. You need to get these things and make sure they're accessible in case an employee or the government asks. And then finally, evaluate the records that you're getting from the predecessor employer, and evaluate the conditions of the workplace. You want to evaluate the status of any outstanding audit recommendations. You want to evaluate gaps in compliance with any OSHA standards. So this might be physical walkthroughs of plants and production areas. to identify any low-hanging fruit, major guarding issues, major, unsafe conditions, combustible dust accumulations, things like that, the sort of things that to the extent you get physical access to the location during due diligence, that you would want to do, I think, a pretty comprehensive safety audit as part of that due diligence to understand what you're buying. And then evaluate the dates when all regulatorily required actions were most recently completed and when they're due next. So if you're buying, a refinery asset, that you understand if you will, shortly after closing on the transaction, will have a PHA that needs to be done, because it takes a fair amount of effort to gear up to do a PHA. You want to understand the status of those periodic obligations and when the next ones are due, so you know what you're buying and when you will have to undertake some of those responsibilities. And then finally, you want to coordinate a complete transfer of all of the records that are required under the applicable regulations that Lindsay talked about earlier in this presentation. You do want to bargain for protective and limiting language in the transaction documents. Language like the existing liabilities will remain with the seller, even though that will not be determinative, that will not be the final say, at least in the OSH context. It is a factor, and to the extent that you can get that language built into the agreement, you ought to try. And then you should evaluate the reality of your transaction against the factors in the Review Commission's substantial continuity test. And that last bullet about thinking about replacing or bringing in new, additional, higher-level safety and health managers, understanding that's the most important factor in the test. You want to look at things and say it's not enough anymore to just say it's a asset transaction and we've got strong limiting language in the agreement, so we will not be found to be the successor. You need to instead do the analysis where you are considering those three buckets, the nature of the business, the jobs and working conditions, and the managers who direct safety and health related decisions. Do that analysis yourself and try to understand, am I likely to be found to be a successor employer? And if so, make sure that you understand the obligations and liabilities of the predecessor and make sure that those are all addressed either before or shortly after you take control of the new entity. So with that, I'm going to just do one quick plug for our blog. Check out the OSHA Defense Report, OSHADefenseReport.com. I think it's the best OSHA blog out there, and I'd love to know someone other than my mother is reading it, so please check that out. And if you're here, you already know about our OSHA webinar series, but look out soon for the upcoming announcement about a 2017 webinar series. We've not lost our stamina yet, and before I go to questions, I just want to thank you all for joining us today and for giving me an opportunity to hide inside of my webinar bubble for at least an hour and a half of the day and forget about the fact that there is this train wreck of a presidential election that's going on. This has been cathartic, and I appreciate the opportunity to spend the time with you. So we'll take a look at some questions here that have come in through the chat function, and if you have other questions, please just type them in and we will try to address them. So what have we got? Has 1904-34 been tested in the courts? I'm trying to remember it. So that's under the record-keeping standard, which specifically is 34. You want to grab the 1910 book. We'll say that you may have stumped us here. We're going to take a look real quick at 1904-34 and address that question. Does this go for government contractors that are in government facilities? So I think, talking about the idea of acquiring, a business or an asset that is operating on someone else's, location, and if that someone else's location happens to be, an Army base, for example, I think the key would be, yes, I think the successor analysis applies regardless of what that physical location is, but what you would be held accountable for would just be those parts of the location that you can control. So to the extent that you are creating a hazard in a machine shop that you are working in an Army base, to the extent you have authority to address a hazard that is located in a machine shop on an Army base, to the extent your employees are exposed to a hazard at some location controlled by the government, if you have employees who are exposed or you control or create the hazard, there will be an expectation that you are addressing the hazard. And if there was some obligation that ran to your predecessor for the same reasons, that will be mapped over to you as the successor, in my opinion. Yep.
Okay, so going back to the question on 1904.34, and just to kind of remind everyone what that standard is, that was the one that I talked about that requires the predecessor employer to transfer records to the successor employer, injury and illness records to the successor employer, but explicitly states that the new employer, the successor employer, does not have to change or update the logs as is required by the standard in normal circumstances. And as far as I know, I'm not aware of a challenge before the commission or in any of the circuit courts. I don't think, I haven't honestly seen this cited very often.
Right.
So, I mean, that could be a big reason for why there has been no challenge to it as well. But the language in the standard itself is pretty explicit as to what's required. I think what could be interesting is if OSHA does end up passing this new rule that would extend the statute of limitations period,
Right.
this could become a much more relevant consideration, and maybe at that point there might be more push to kind of define the parameters of this particular standard. But I think at this point it hasn't really been, challenged. To mind, I'm not aware of any cases, but if it is, it would probably be very limited.
Yeah, and so I think, to Lindsay's point, I think this is an issue that might become more prevalent in light of the two new record-keeping rules we may be facing. One, the electronic record-keeping rule that, at least right now, your 2016 records are going to be produced to OSHA in July of 2017. And then if the statute of limitations is extended, and I have heard from my contacts at OSHA that they intend to get the Volks rule finalized before the new administration. So here you will face situations where an acquirer will have an obligation to report the injuries and illnesses of the predecessor, and I think you might run into circumstances there where OSHA becomes aware of the fact that a new employer either did not take custody of the records of the predecessor because they're not reporting them in the electronic log, and may try to make an issue of it. But right now, this has scarcely been addressed, and one of the reasons is that OSHA has had their hands tied with a 6-month statute of limitations, and there's just not a lot of visibility into old record-keeping issues like that. But I could see this coming up as an issue because of the new record-keeping rule and the new statute of limitations. So here's a great question, and this is one that I have dealt with for a number of my employers. The question is, I understand the discussion about what documents need to be kept, but if we were about to acquire a business that simply did not keep these sorts of records, how are we able to produce for OSHA the records if we never received them? Would OSHA be satisfied with we never received these records answer to the inquiry? I would say that your obligation is a obligation of reasonable, you need to be reasonable and exercise good faith to obtain the records. And if you can establish that the prior employer, it's not just that they wouldn't give them to you, it's that they never created them to begin with, and you make some effort to create or recreate what was not handed over to you, to the extent that's even possible, or demonstrate that it's not possible, I think you would be in good stead. What I would do is document as effectively and thoroughly as possible all of the efforts you made to get the records from the predecessor, and hopefully getting something in writing from the predecessor that demonstrates they did not develop or create or maintain or are not or cannot produce to you during the transaction those records, so you can demonstrate we did everything we could within reason to get these records and couldn't, and here's documentation that shows that the old employer didn't or couldn't produce them to us. And then to the extent you're talking about injury and illness record keeping records, for example, they just didn't keep 300 logs. I think there is still a good faith obligation to go back through what records you do have, your workers' comp records, your first aid logs, your any medical records you do have, and try your best to create at least the current year's log. Right now I would say, look, going back only 6 months, but when they extend the Volks, if they do that Volks rule, to try and go back as far as you can to try to recreate those records, but, hold on to that argument that, hey, the predecessor did not have records to give us, or for whatever reason did not or could not give them to us, and we've undertaken our best efforts to recreate those records, and this is what we've got. I think that would be adequate. All you can do is be reasonable. Here's one last question. Oops, I lost my screen. One last question that says, where did it go? How far back? How far in advance can an acquiring company begin to request IH survey results, OSHA 300 logs, medical records, etc. from the company being acquired? That's a great question, and that's generally going to be, it's different transaction by transaction, and the two parties to the transaction will sort of develop a due process protocol. I would think the earlier in the process, the better. But it's going to be different transaction by transaction, and whatever sort of the attorneys on both sides of the deal kind of negotiate for will sort of set the stage there. And certainly how far back you can go requesting that information is, again, going to be a function of what the two parties bargain for in the transaction. Your request should be reasonable, but by that same token, since these things are 30 years or life of the process, I don't think it's unreasonable to ask for all of that information. They may balk at it, and you may have to deal with that with your lawyers. But I think the more information you have, the better. So the more you should ask for. Whether you get it, how far in advance you get it, is going to be a function of how the deal is run by the transactional attorneys. So that was all the questions we've got up here in writing. I will tell you, we've got our contact information up on the screen. Don't ever hesitate to reach out, call us, shoot us an email. We love talking about this sort of stuff. I'm a huge OSHA nerd. I would love to hear about, the challenges, opportunities, and, positive outcomes and crazy outcomes that you've encountered in this space. So please don't hesitate to reach out. And likewise, of course, if there's ever anything that Lindsay or I or the rest of our team here at Conn Maciel can do to help with OSHA or labor and employment issues, we would love to be a resource for you. So thanks for joining us today, and I hope you join us for future webinars. And happy Election Day.